The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty from O'Flaherty Law. I hope you find this Learn About Law video and podcast helpful. If you need some help, please feel free to give me a call at 630-324-6666. That's 630-324-6666. Thank you so much for watching and listening.
Hi, this is Andrew with Learn About Law, and in this video we will discuss temporary custody hearings in Illinois. So the purpose of the temporary custody hearing is for the court to ascertain whether it should, 1, retain jurisdiction of the case, and if so, 2, whether it is safe for the child to maintain at home during the court process, or if the child should be placed elsewhere. If during the temporary custody hearing the evidence presented suggests there is probable cause to believe the child has been abused, neglected, or dependent, the court will continue with its case. At this point, the court must also determine if the child's safety is of immediate and urgent necessity. If so, the child will likely be placed in another home for the duration of the case until the final judgment is handed down, or an attorney for the child's parents obtains an order to have the child return home before the final judgment. What documents should be present at a temporary custody hearing? So the petition alleging abuse, neglect, or a dependent minor can be filed by any person, agency, or organization, including the state's attorney. The documents and reports present and available at the temporary custody hearing are typically going to include the state's petition for adjudication of the wardship, the Division of Child Protection investigators' request for filing an abuse or neglect petition, the accompanying witnesses' statements, a risk assessment chart, and the Child Welfare Agency's reasonable efforts checklist. All abuse, neglect, and dependency proceedings require 3 parties: 1, the minor; 2, the state; and 3, the parents, guardian, etc. The child will be represented by a guardian ad litem, and the state prosecutes the case. All parties involved have the right to counsel and the right to be heard, present evidence, examine, cross-examine, etc. Previous foster parents or child welfare agencies associated with the minor also have the right to be heard during the proceedings. Based on the court's ruling from the evidence presented during the proceedings, there are 3 potential outcomes in a temporary custody hearing. 1, the court finds that there is not probable cause to believe the minor was abused, neglected, or is dependent. The petition is dismissed and the minor is returned to the legal guardians if currently in protective custody. Or 2, the court finds that there is probable cause to believe the minor was abused, neglected, or is dependent. The court retains jurisdiction of the case and the custody hearing is set. At the end of the hearing, the judge orders the child to be removed, at least temporarily, from the home and placed with the appropriate legal guardians. And then 3, the judge orders that the child can remain in his or her current home, but orders the home remain under supervision by an agency such as DCFS and an appointed child protection officer. Poor representation in a child custody hearing can mean the difference between keeping your parental rights and losing your child. If you have any questions about child custody hearings, please give us a call at 630-324-6666. And as always, thank you for tuning in.
Hi, this is Kevin O'Flaherty again from O'Flaherty Law. Just want to let you know we offer free consultations in many areas of law, and we have several geographic locations for your convenience. So if you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. And thank you again for watching and listening.